Friday.
Ooh.
We love Friday. Why do we love Friday so much?
Because it's the last day of the week.
Civil procedure. Exactly right. Let's go back to, we have so much to do today. So much to do this semester. Let's jump right in and go back to what we were talking about when we left off last time, which is the Iqbal case. And we love the Iqbal case. Unless you're me, I hate the Iqbal case. But that's okay. If you go into a plaintiff's practice, you'll see why. What was it that the district court said? What was the standard that the district court used in the Iqbal case? The district court. Remember, that's the itty-bitty court. Right? Yes.
So I know what they said. I don't know exactly what the standard is,
Yeah.
but didn't they say that there was, it cannot be said that no set of circumstances where this couldn't be true or something like, basically, yeah.
That's it. Look with me on 351, those of you that have your books, at the very top of that. All right, and this is the thing that you should be tuning your brain to when you read these cases by now, right? What happened in the lower court? Why did the lower court rule the way it did, and how did it get to the court that you were reading in, okay? So the district court here says the motion to dismiss, there's a motion to dismiss that's made by the defense. We'll talk about those. Motion to dismiss is granted or denied?
Denied.
Denied, right? And the court says, because it cannot be said that there is no set of facts on which the respondent would be entitled to relief. Okay? So it's possible. That's the important thing to cling on to here. Before, in a world pre-Iqbal, if you pleaded something that looked like it was possible, that it could have really happened the way the plaintiff said, well, then the district court will let you slide and you get to litigate your case and do discovery and do all the fun things that we'll learn about the rest of the semester. Okay? Supreme Court says, no. We're gonna change that just a little bit. We're gonna tweak that slightly. What's the standard that the United States Supreme Court wants to use under Rule 8? Not possible, but yes, plausible. Plausible. That's the thing. That's the important thing to walk with. Yeah. In the pre-Iqbal universe, you could plead things that were possible, get away with it, and now you must plead things that are plausible. Oh, so that makes a big difference in our jurisprudence, right? How? Well, let's talk about that. Yes?
Well, in terms of going from possible to plausible, it would supposedly, in theory, at the very least, narrow down what actually goes to the court as it cuts down on like what could potentially be frivolous lawsuits.
Let me jump ahead. Well, actually, I'll ask first. What do you think the effect of the Iqbal case has been on the lower courts? What do you think's happened? Go ahead.
I mean, besides confusing the courts, it also makes motions to dismissing cases easier.
It makes it easier to dismiss cases if the judge wants to.
Mm-hmm.
What sort of effect do you think that has on any old case, right? What sort of effect do you think that has on what gets filed in a case? Put it that way. Yes?
A lot more detail and have a lot more stuff up front than you would have had previously.
That's true. What is something that you may not have had so much of in the past, pre-Iqbal, but now you get a lot of in cases, right at the beginning of the case? Yes?
A lot more facts.
Yeah.
Well, a lot more facts in the complaint, yes. A procedural device used by a defendant. Not used as much pre-Iqbal, now used a lot. Citing Iqbal. Yeah, I'm jumping ahead here. But a motion to dismiss. Right? A motion to dismiss. The procedural device that got the Iqbal case to the Supreme Court to begin with. Because now, in a post-Iqbal world, why not? Right? Put your defense hat on. Why not take a run at it? Why not see if the judge thinks that, in fact, what the plaintiff has pleaded here is not plausible. Because what does plausible mean? Let's think about that. First, while I'm still on this slide, look with me at note 11 on 361. The only thing I want to say about that is that this, in my opinion, does not take the situation quite as seriously. And perhaps the practitioners that wrote this book have practiced in more forgiving jurisdictions than I have. But this note says, well, usually the courts won't just kick the case out altogether. They'll give you a chance to replead the case. Nope. Nope. Not in my experience. Not in my experience. Get it right the first time. Okay? Get it right the first time. When you draft your complaint, get it right the first time. How do you get it right the first time? Well, the Iqbal case isn't super clear about that. Look with me back on 352. Section 4A, that first paragraph. Kennedy says, Rule 8 does not require detailed factual allegations. Okay? Does not require detailed factual allegations, but it demands more than it adorns the defendant unlawfully harmed the accusation. Okay, well, all right, Papa Kennedy, that sounds somewhat reasonable. Jump ahead to 353, the very last paragraph on that page. What is the respondent, what does Mr. Iqbal say in his complaint? What's the language that he uses? You see it? That's the language from the complaint. Sorry, what?
Knew of, condoned, and
Yeah.
willfully and maliciously agreed to subject a harsh condition.
Right, right. These defendants, in other words, these defendants knew what was going on, which is violation of civil rights. Right? They knew what was going on and they condoned it, and that says that pretty clearly there. Right? As a matter of policy, solely on account of his religion, race, and or national origin for no legitimate penological interest. What's the court's problem with that? Why don't they like it? Yeah.
Because it's just a conclusion without anything to back it up.
It's the legal, that's right, that's a good way to put it. It's the legal language, it's a legal conclusion, right? That, in this court's estimation, does not have any facts to back it up contained in the complaint. Now, as I was just talking about with Neil before class started, how would you get those facts? Discovery. Discovery. When do you do discovery? Well, after you've survived the motion to dismiss. So, anyway. I think, well, and let's look at some specific language here. This is really where you get your money's worth for today, and out of the Iqbal case. How do you determine what's plausible? Well, Kennedy tells you. Could it be any clearer than this? Could it be any more plain how to determine what plausible is? It only makes the difference between life and death for your complaint. But this is clear as day, isn't it? It's a context-specific task that relies on judicial experience, and common sense. What could be more simple than that? Now, I'm a cynic. I've already said that. What do you think Kennedy is really saying? What's he saying that plausible is? Translate that to layperson speak. Yes?
It's whatever they want it to be.
Whatever they want it to be. I like that. Yeah. Whatever the trial judge wants it to be. Right? Possibly the appellate court too. Right?
I mean, could it really be that? Because just continue to appeal until they get to a judge that's more likely to, say what plausible means in their favor.
How often do you get to do that? How many appeals do you get to have? As a matter of right, how many appeals do you get to have? One. What is the likelihood that the Court of Appeals is going to say, no, we think it is plausible, and what the lower court said about it being implausible, we don't agree with that. What's the likelihood of that? Yeah, I'd say about that. 80 bit, okay? 80 bit. Not impossible, but implausible. Yeah.
That seems to be an issue for me because that makes that standard way too subjective, and for jurisdictions that might already want to like be in favor of either one side or the other based on what they already know, they could easily like construe that and make some things impossible if it's not, or make something seem impossible when in reality is possible.
Yeah, no, I agree with you. I agree with you, but I'm a plaintiff's attorney, and I've had to deal with a whole bunch of these motions. And I will bring you defense attorneys who will present you the other side. We have our plaintiff's hat on today anyway because we're in complaint work. So we want to make these complaints the best that we possibly can. But what I think Kennedy really is saying here is essentially giving free rein to trial judges to do away with cases that they don't like. Okay? That's an extremely cynical take. But in practice, it has increased the number of motions to dismiss that have been filed in the district courts dramatically, and I suspect, although I have no evidence to back this up, it's increased the actual number of dismissals. Okay. Federal Rule 9. Questions about Iqbal before we move on? We'll refer back to it every now and then. I mean, we plaintiff's attorneys call it getting Iqbal, right? We basically expect that, especially in civil rights cases, especially in the civil rights context, you're going to get a motion to dismiss. Right? And so you craft your complaint accordingly. And that means looking back at what he says about Rule 8 on page 352, 4A, that we already looked at. Rule 8 says that it doesn't require detailed factual allegations. Yes, it does. Right? For you, when you're drafting a complaint, yes, it does. Right? You want to draft a good complaint, put in as much detail as you possibly can. How do you do that? Well, we'll talk about it. Federal Rule 9. The only big thing that I really want you to know about Federal Rule 9 is that, and the thing that pops up consistently in practice, is that issues having to do with fraud must be pleaded with particularity, okay? Just like it says in the rule. The rest of the rule, I don't think that you'll find yourself dealing with all that much unless you become a maritime lawyer. Many of you will not. Okay. Under Iqbal, you're pleading, under Rule 9, you plead fraud with particularity. Under Iqbal, I'm telling you, you should probably try to plead everything with particularity. And that includes, as your book notes, in answers. Jumping ahead just a little bit. If you're answering a complaint, put your defendant hat on. You're answering a complaint and saying, yeah, I violated the terms of this contract, but it's because I'm using fraud as a defense. It's because the plaintiff defrauded me. There was fraud in the inducement, or whatever they call it in contracts, right? Then you'd have to plead that with particularity. Also, one little nit to pick on 367, you don't have to turn to it, but a lot of these case books talk about the uptick in civil rights claims, and particularly the uptick in frivolous civil rights claims. And as a civil rights lawyer, I take issue with that. There's of course been a dramatic upswing in civil rights litigation since the 1980s. Does anybody want to hazard a guess as to why that is? Is it because we've all become so much more litigious as a society in the last 30, 40 years? Or might there be some other root cause to the dramatic upswing in civil rights litigation that has been filed since then? What do we think? Yeah.
You didn't have the legislation or like the law in place to file those claims before 40, 50 years ago, right? So
That is partially true. That's partially true. And if you take my civil rights seminar, which of course all of you will, we go through the history of what's called 42 U.S.C. 1983, which is your vehicle for getting constitutional actions into the federal courts. Right? And that's become somewhat more lenient over the years. But what also has happened in society that might have caused an uptick in civil rights litigation over the last 40 years? We just like filing lawsuits more. Nobody has a guess on this one? Yes.
Yes. Is it that, I'm not sure if it's like at-risk people are now more able to file civil rights, whether it be like they have easier access to attorneys, more attorneys are willing to fight civil rights cases?
I don't think so. I don't think so. It's really hard to find somebody to take these cases. A lot of the litigation that's been filed is pro se. Hint, hint. Right? Pro se, filed by people who don't have a lot else to do with their days. Yeah, Kelsey.
Incarceration?
Incarceration, mass incarceration. How much has incarceration increased since the 1970s?
60%.
A lot, okay? A lot. So you have a lot more people that are sitting around that don't have a whole lot to do other than file 1983 suit after 1983 suit. Whether right or wrong, that has been a big consequence of incarceral state. Okay. Prayer for relief. Remember we talked about prayer for relief a little bit on Wednesday. Your book talks about the need to include a specific dollar amount in your prayer for relief. I do not agree with that. It has not necessarily been my experience, but that differs from jurisdiction to jurisdiction, and make sure that you are checking the local rules in your jurisdiction, okay, before you file anything. As we've already seen, Kentucky Civil Rule 8.01, which is the counterpart to Federal Civil Rule 8A. 8.01 says what? The second part says what about putting dollar amounts in your complaint? It says don't do it. Did I put that on the, yeah, I already put that on the slide, so that's an easy one. Okay. It says don't put claims for unliquidated damages in your prayer for relief. Okay. So that varies greatly from jurisdiction to jurisdiction. You have it on that civil cover sheet, and I rarely, and perhaps this is my error, but I rarely put it in a prayer for relief in a federal complaint. We don't really know what damages are until litigation drags on. Okay? But the court's not limited to what you put in the complaint anyway. You take care of itemization of damages throughout the discovery process and in your pretrial pleadings. Okay? Any questions about any of that stuff? Prayer for relief? Yes.
for that dollar amount, like I know in Kentucky, it's you put in the jurisdiction and venue, like this court has jurisdiction because damages exceed the jurisdictional limits.
Yes. Uh-huh.
Can you do that with federal? Just say like it's over $75,000.
If you need it for diversity purposes, yeah. But I would put that in your statement of jurisdiction, not your prayer for relief. Everybody here has questioned So if you are pleading in a diversity case, and you want for some reason to file in the federal court as a plaintiff, then in your jurisdiction and venue section of your complaint, because you always have a jurisdiction and venue section in your complaint, say the amount of damages and controversy here is over $75,000. That's all you gotta do. That's all you gotta do. And then you put that, as we saw on Wednesday, in that civil cover sheet too. Good? Yes? Keep going? Problems. We love problems. Now remember, on the final exam and in real life, these are not math problems. Okay? They're not chemistry problems. They don't have right and wrong answers. But explain your rationale. Maybe some of you think that this isn't enough to make the claim. Under Iqbal, or under Rule 9, or under whatever standard. Okay? But explain to me why. Maybe you think it is. Explain to me why. Okay? That's what you do when you're a lawyer. And I assume that many of you are going to become lawyers. Okay? So, what do we think about this one? Defendant owes plaintiff $100,000 for goods that plaintiff delivered to the defendant on August the 9th. That's all they say. Is that good enough? Who says yes? Good enough. Who says no? Wow, really? Okay.
I think I just put this is your question.
All right. Morgan, you got him?
Yeah, I was just gonna say no, because like, it's possible. There's not like a reason why maybe he owes the $100,000 or just as good as anything else. There's not an email to it, doesn't say why.
Remind me not to have you as a judge on a case. Too harsh. Too harsh. Who wants to say yes? Argue the other side of it. Yeah. Tell me your name. I'm sorry.
Jessica?
Jessica, go ahead.
I mean, if we assume that these were the only goods that there was ever a contract between these two for, then yes, they're being specific about what was delivered and even the date that it was delivered. Would it be nice
it's
if they?
pretty straightforward.
I mean,
You owe the money,
granted,
and I'm
like,
suing you to get the money.
granted, I could see like the defendant raising the objection, saying like they didn't say anything about like method of delivery. But apart from that,
if I am the world's most tyrannical judge, I can say, all right, defendant owes plaintiff $100,000 for goods the plaintiff delivered to defendant on August 9th. But the complaint doesn't say that he didn't get paid, so out goes the complaint, right?
but if he says
I
like
think
he
it's going to
owes
be
me
implied in the
$100,000,
rest
then that
of
means that
the complaint, right? I lean towards this being an okay, not good, but an okay, a passable statement to have in your complaint. Probably survives a motion to dismiss. What about this one? What's the difference here? Defendant receives several large shipments of different goods from the plaintiff on the date in question. Defendant owes $100,000 for goods plaintiff delivered to defendant on August the 9th. Well, now we don't know which shipment we're talking about. Okay? Now it's a little bit more confusing. So I think this one is on shakier ground than this one. Okay? But as with everything, it depends on who your judge is. Okay? Are there some judges that would kick that one out? For sure. Are there many that would leave it, let it stand? Yes. Same goes with the second. Make your case, right? Make your case, since we have to deal with these problems. Someone touches on Rule 9 and 10. Okay. Plaintiff sues the defendant, car dealer, for rescission of contract. Plaintiff's complaint says, assuming without more, right? Defendant salesman purposefully lied to plaintiff about the condition of the car in question. Who says this gets dismissed? Who says it gets to live? All right. You say it gets to live, make me a case. Go ahead.
Well, I know he's using kind of like a fraud-esque. He's using fraud for the reason why he wants to rescind the contract. And I think the fact that the salesman purposely lied to the plaintiff about the condition of the car is probably enough. Like, of course you don't have your factual background without discovery, but I think that's enough to say, okay, if that's true, then yes, let's rescind the contract.
Okay. All right. But you would say, you think though that this does touch on fraud, right?
That would be
This
my
implicates fraud.
Right.
So what's the standard for pleading fraud? You must plead it with particularity. Very good.
You need to plead fraud if you're using it as part of rescission for the contract, like just okay. So
Yes.
Yeah.
Yes. 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 I don't think this is pleading with particularity. Okay? I don't think so. If you think it is, be prepared to make your case. Fine. There ain't no right and wrong answers to law.
Can I ask a question?
Yes, sorry.
So then, can you rephrase that in a way that it would be acceptable for fraud in particular?
I think you gotta talk about the condition. I think you gotta talk about the contours of the lie, and I think you gotta talk about the condition of the car. Right? I think you gotta say more about what actually happened and why you were defrauded. So, if specific examples, I don't know, but yeah.
Well, are we saying like that this isn't like the factual background part of the complaint, or like once it gets down to where you plead the different?
I don't write the problems. This is, yeah, I mean, I think I think we're talking about the claim, right? And that this is the only thing that exists for the claim without any other background and without anything else. Right? And of course you would never draft a complaint that way. Of course, none of you, having taken this class for 2 days, would ever draft a complaint like that, right? Put more in. If there's ever a question in your mind, put more stuff in there. Okay? And I think that what makes it, go back to Kennedy's language on the bottom of 353. Well, not Kennedy's language, Mr. Iqbal's language, right? He doesn't like this. These are bare assertions. So the question is, what makes them not bare assertions? What would help improve this language? Facts. Yeah. Some kind of factual information that corresponds to this legal conclusion. And then I think, at least theoretically, it survives. Well, if the judge doesn't like the case, it goes, right? Respondent pleads that petitioners knew of, condoned, and willfully and maliciously agreed to subject them to harsh conditions of confinement. And here's how I know that. Here's how I know they knew about it and they did it on the basis of my race or religion or national origin. Give the court that extra mile of facts.
Well, I think they did try to do that though. Like
I know. Look, I know. I know. I told you. Okay, so how do we draft a complaint even after having gone through all that stuff? Well, let me bottom line some of the stuff that we have looked at already. Okay? How detailed you got to be in these complaints? You got to be very detailed, right? If there's any doubt in your mind that you should put something in, put it in. Assume that you're going to get a motion to dismiss. And a lot of what civil litigation is kind of looking 3 or 4 steps ahead. What's this motion for summary judgment going to look like? What's this motion to dismiss going to look like? What's trial going to look like? Right? So it's always thinking ahead to some future event and sort of planting the seeds where you're not totally screwed when that future event happens. Right? And until you've responded to a few motions for summary judgment, it's really hard to take depositions. Has anybody sat in a deposition yet? Oh, a bunch of you, good. Yeah. And you may sit in a deposition your first couple of times if you haven't really worked on summary judgments before and be like, why are they asking all these questions? What is going on? What is happening? Why does this matter? This is a big giant waste of time. And then you respond to a couple of motions for summary judgment and think, that's why they asked that question. Okay. This is kind of the same thing, right? You're laying the ground. You're laying the grounds to survive a motion to dismiss in your complaint. Okay. So break down your elements of your torts or your statutory elements or whatever it is you need to do, and for each one of those elements, tie it to some facts if you can. Even if it seems ridiculous and pedantic, do it. Lawyers are ridiculous and pedantic. Explain how all the prerequisites to suit have been met. We've already talked about that. That's jurisdiction, that's venue, that's amount in controversy, it's everything. Explain why certain defenses won't work. Well, I mean, in this Iqbal case, they talk about qualified immunity, which you guys probably don't know anything about yet. Of course, if you take my civil rights course, you'll learn all about qualified immunity. But it's important to talk about immunities, governmental immunities, any kind of immunity that you think the defendant is going to raise. Put that in your opening shot. Okay. Just as an example. And remember that language about incorporating the previous parts by reference. That's important. That's important. If you have this big, long fact section, we looked at a complaint on Wednesday, the Tamir Rice complaint, where you have this big, long fact section, and each one of those counts is just one sentence. Okay? And if you get a really cranky, really crotchety old judge that wants to do away with your case, and say, well, look, there's no facts to support the claims in these one-paragraph counts. Right? So let's toss that out. And at least you can go to the appellate court and say, well, look, we incorporated all those facts by reference into each one of these counts. Again, ridiculous, goofy legal fiction. Sometimes it really matters. Is everybody with me, or am I just like way out in strategy? Good? Yeah.
Can you post this slide later?
Yes.
Thank you.
You can send me an email reminder. You don't need both sides. This isn't a statement. When I say put everything in there that you can possibly put in there, don't make the defense's case for them in a complaint. This is one of the few times in litigation you truly get to hold and hit. Right? This is your case. And remember, it could be consumed by members of the general public too. You don't need to give both sides. Very oftentimes reporters will grab a complaint, look at the allegations in the complaint, that's all they ever report on in the case. You don't need to give both. Have you guys seen this in complaints? Upon information and belief, blah, 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 blah. Yeah. If you look at enough complaints, you'll see it. It's a way that you can kind of say, I think this is kind of what happened, but I'm not sure. Upon information and belief, plaintiff defendant was involved in the Oklahoma City bomb. Okay? I mean, you can't be way out there with this stuff, but it does give you a little bit of padding when you say upon information and belief. Just be prepared to answer the question of what is that information and belief if it ever comes up in a dispositive motion or a deposition. Okay? Good with all this? Right. Interestingly, have all the states picked up the plausibility standard of Iqbal? No. Including Kentucky. Right? Kentucky hasn't really said, yeah, it should be the plausibility standard in Iqbal. I would still draft a state complaint as though we were drafting it for the federal courts. But if you get bounced out in the state court, you've at least got state case law that you can go back to the appellate court with and say, look, they shouldn't have tossed this out. Kentucky's just a notice pleading state. We don't do all that complicated plausibility stuff that they do in the federal court. That's for the big brains in Washington, D.C. Yeah, questions about any of that? Have to draft your complaint. How do you do it? Where do we go? How? We're still so confused. Well, look, you've learned how to be somewhat resourceful in your year plus of law school at this point, right? You know that those forms libraries on West and Lexis, we looked at those. Yes. Pacer, what's Pacer? Yeah.
That's an online filing system used by the courts, and it's also a public records system.
Yeah. Yeah, you can access any federal complaint that's been filed in the last 15 years, in most places, on Pacer. So if you find a case that's substantially similar to yours, and hopefully went the direction in the courts that you want your case to go, you can go find that complaint. You can go find complaints that have survived motions to dismiss. Also, ask other lawyers. The profession is generally very good about that. I still find myself, once every couple of weeks, reaching out to other lawyers to say, have you ever filed something like this? Can you share your pleadings? People are usually very generous about it. And if all else fails, Google it. How do we feel about this? Pretty good? Can you draft a complaint?
That's what you're
Can you do it?
That's what you're on Vegas tube, isn't it?
In 40 minutes?
Yeah.
All right.
Called it.
You can do it. What if you work in groups?
Oh man.
Here it is, McCoy versus Hatfield, because I didn't have the foresight to make a Hatfield versus McCoy. Sorry about that. But this is it. You represent Mr. McCoy. Get into. I'll go back to that. Don't worry. Get into groups of 5 or fewer. Okay. You want to work by yourself? That's fine. I don't care. But 5 or fewer should be your groups. One copy of the complaint on behalf of your group before you leave today.
Sir, you just want us to write them down, or
Type it out.
Type it out? Okay.
Yeah, type it out someplace. So, hey guys, what you can do is, and folks that have been in my writing class know that we've done this before. If you want to pull up like a Google document that you can all type on, that might be the easiest way to do it. Or you could just designate someone as secretary that writes everything down. That's more of a pain in the ass, but if that's what you want to do, fine. I'm looking more at form than substance. Don't worry about complying with the rigors of Iqbal on this thing. But, you know, it's a battery case. Can you break down the elements of battery and tie the facts in? I think you can. I think it's pretty simple, right? Get as creative as you want. I'm looking at form. So if you've got all the areas that I posted on Blackboard last night, everybody saw that, right? All the areas of the complaint that we talked about in this class on your complaint, then you're probably doing pretty good. And I may even let you slide if you're missing a few.
So you want to type?
Yeah. Wait, no, I don't want to type. I suck at typing.